Facebook Live broadcast. We're going to kind of pick up where we left off last time. Pat, great presentation last time. I got a lot of feedback that it was very informative. People learned a lot of things. So I think it might be good for us to just start by recapping some of those points for anyone who hasn't watched it. Does that make sense? That's a good place to start?
For sure. Last time I talked a lot about kind of the basics of estate planning, how wills work, how powers of attorney work, that kind of thing. So just to recap, medical powers of attorney, pretty straightforward. Let someone make your healthcare decisions for you. Lets the hospital talk to you. I'm sorry, not to you, but to your family members if they have questions, and lets them make those vital decisions for you. Financial powers of attorney are a lot more diverse. You have some that are really, really narrow and really don't let someone do much. And you have some that are very broad. And the thing is, they're all called the same thing. They're all called powers of attorney. They're all called verbal powers of attorney for the most part. But some really tie your hands and some really let the family act. So it's really important to make sure you've got the right powers of attorney.
Pat, sorry to interrupt, but one of the really good points I think you made last time is just the difficulty with the situation we're all dealing with right now. Courts being closed, how does that play all into this? Because if you need guardian and conservatorship, you might be in a difficult spot.
Oh, very much so. Ordinarily, the second best option, if you don't have a power of attorney, is to go to court and have a judge appoint you guardian or conservator. It's a slow process, it's a costly process, and oftentimes people wind up fighting during that. But now you can't even do that in most cases. The courts are closed, the hours are restricted, and what options are available are kind of slim to none. Like I said last time, we had a call last week trying to reach out to somebody who is in a hospital. And how do you get things done then? And we've really got to do some outside the box thinking to get that handled, because the normal order of things is largely broken down. So how do we work within that?
Right. And a question that I get so often with the powers of attorney is people talk about using it after someone has passed away. Does a power of attorney continue to work after someone has passed away, or when does it work? Does it work immediately? How does that all work?
So a power of attorney, great question, Mike. Power of attorney is a lifetime.
I'm going to answer one at some point.
All right, sooner or later. A power of attorney is an in-life document. It only works while you're alive, and it stops working after you've passed. Now, some are effective immediately, and some only go into effect on your incapacity or disability. That depends on the specific language in there. But what's uniform throughout all powers of attorney, medical, financial, no matter when they go into effect, they stop working when you do. And that's when a will, a trust, probate, all those things start to come into play. That's the estate planning side of things.
Yeah, very nice. That's what it's so often. So many people think that they work after the fact, and they might even try to take them to a bank and use them after someone has passed away, and you just can't do that.
Right, and the flip side is true with the will. A will is an after death only document, but people will bring it in and try to show a nursing home or our office, and they'll say that they're their parent's executor. But if the parent's still alive, that will doesn't do anything at that point.
Right. Good. You touched a lot last time on that. We might be talking this time about trusts, maybe differences between wills and trusts. Mm-hmm. And as I'm sure you experience, one of the most common questions that we get as estate planning attorneys is, what is the difference between a will and a trust?
Yeah, I would absolutely agree. Would you like to take that one?
Sure, let's do it.
Yeah.
Okay, thanks for passing the ball. Okay, so there's 4 basic differences between a will and a trust. We'll dive a little bit deeper into each of those, but essentially, a will has to still go through the probate process. So this is the administration of someone's estate after someone has passed away. A lot of times we have questions about, how long does that take? What does that cost? Statistically, our averages on that is it's usually anywhere between 9 and 18 months before a judge is going to sign off on the distribution of assets. and it can cost anywhere between 5 and 10% for the value. 5 and 10% is the cost to take those assets through the probate process, between attorney fees, court costs, inventory fees, those kinds of things. So that's a lot of times, many people's number one goal is to avoid that probate process, because unfortunately here in Michigan, it's not an easy process to go through. So that's the first thing. Second, a trust is a private transaction where a will is a public document. What I mean by that is when you have to go through that probate process, your will is now recorded for the whole world to see. And this is how sometimes we see in People magazine, when celebrities do terrible estate planning, we get to see how much there was, who got what, that information is available to everyone. And a lot of times I talk about, well, people are, well, why does that matter for me, right? And what we see on our end is just family fighting over things. When the whole world can see how much there was and who got what, it just is inviting everyone to the table to say, I deserve more than I got. Does that make sense?
Yeah, so you're telling me that no matter how clear, precise, concise a will is, it's going to go to probate and everyone's going to get to see it if they want to? That seems shocking.
I know, right? But Mr. Carrier, you are correct. They are all going to go through probate.
How about that?
Yeah, right. Moving on to the third big difference between a will and a trust is that in a trust, you can be a lot more flexible in the distribution of assets. Good example here is, what if you have some minor kids and you want to delay the distribution to those kids so that they don't have availability of the assets early on in life? You might want to put some parameters around the money can be used for education, medical bills, the important things you would have provided for if you were there parenting your kids. You can write that all in a trust and just have control over how that distribution goes, instead of them getting a large lump sum at some point in their life earlier probably than you would have liked them to get it. And then the final thing in a trust is we can protect assets in a trust. So there's a lot of trusts. We're going to talk about some different styles today. But essentially, we can protect assets for your beneficiaries, meaning, what if one of your kids is in the middle of a divorce? Assuming your kids are your beneficiaries, but what if one of them is in the middle of a divorce when you pass away? There's ways that you can protect that distribution to make sure that your kid gets 100% of everything you wanted them to get, instead of a soon-to-be ex riding off with half of your daughter or son's inheritance into the sunset.
I know, I would hate to see that happen.
Yeah, right. And the unfortunate thing is we're kind of joking about it right now, but it's a reality and it happens. And it happens all the time. Yeah. Things also that could be going bad in someone's life. And, we don't have a crystal ball to look into the future to say what's going on. But what if there's an alcohol problem, addiction, dependency? What if they gamble too much? What if they're being sued because they got in a car accident? Any of those things can be protected in a trust where, because we just don't know what the future holds. And then the final part of that asset protection is we can protect assets for you, the grantor or the person who created the trust during your lifetime.
I was going to say, Mike, what is a grantor?
Yeah, it's a tricky term, right? It's essentially the person who created and funded the trust. But we can protect someone's assets while they're alive from things like long-term care costs, bankruptcy, creditors, lawsuits. Fascinating, right?
Yeah. It seems like these trust things might be worth paying a little bit of attention to.
Yeah, they are for sure. And feel free, anyone watching this now or whenever, reach out and ask questions. But you can also ask questions now, and we can kind of field them as we're going along.
Yeah. So from my understanding, from talking to a few thousand families over the years, all trusts are exactly the same, right?
They're all
a trust is a trust, right?
Exactly. The same one that you download on one of those fancy websites is the same one that your comprehensive estate planning attorney is going to provide for.
It's like bananas. You see one, you've seen them all, right? Or would you say maybe there's a little bit more nuance to it?
A little difference. I feel like you really want to touch on that a little bit.
You know what? I will. There are actually, a few dozen, 100 different types of trusts out there. And all of them do different things. So I'm going to break down kind of a few different types, a few different categories of trusts. But a way to think of it too can kind of be like a car, like a vehicle. And there are categories. There are things that are cars, there are things that are trucks, there are things that are vans. But under those subsets, there are a whole bunch of different types that all do different kinds of things. So when you say trust, really what you're saying is vehicle. And then after that, there are all these different subtypes. So we're just going to kind of talk on some of that today. But this is entire semesters worth of law school work. So we're just we're gonna give you all of that here today in about 15 minutes.
Let's do it.
All right. So two big categories. One is living trusts, and the other is testamentary trusts. And the way they work basically is a living trust is any trust that you set up while you are alive. That's it. It is a living that you set up for you while you're alive, because it is a living trust during your lifetime, as opposed to a testamentary trust. And a testamentary trust is something created either by your trust or by your last will and testament.
So Pat, I have a question for you on that. I was actually working with a family yesterday who had a testamentary trust created out of will. Mm-hmm. It's funny. We find often that people think that that's a trust when their will gives guidelines as to maybe later distributions to minors or those kinds of things. If you did a testamentary trust under a will, would that still have to go through probate?
Yes, it would. The way that trust is created is through probate. So you can have a will that says, create this trust for my kids, but the way that happens is through the court system, is through the probate process. And this is also probably a good time to mention, there is something that people think of as being a trust that is not truly a trust, at least not in the way most of us think of them, is a trust fund. A trust fund is you're very, very wealthy, some great uncle way back in the day set this up with oil money, and some trustee or law firm administers it and pays out an allowance, things like that. People think of trusts as these tools for generational wealth for the super wealthy. And while that is one pretty tiny aspect of what they do, it is not really what a trust is in the conventional sense, or even in the way that we use them. But a lot of times people will say, well, I don't have, $100 million to leave over the generation, so I don't need a trust. Not necessarily the case there. But just to say those.
Let me ask you on that too, because I get that question a lot also. Like, at what point in time in your mind are you saying this might make sense to have a trust?
Well, it's a good question, and it's also one that has a bunch of different components. There's no, specific exact, okay, at this date, because what you'll see sometimes is you'll see like a younger family that maybe they don't have a huge amount of assets, but they're young professionals who have been investing in their retirement accounts, and they also have very, very substantial life insurance policies. Well, who's the beneficiary of those policies? So what people will do is they'll have a will that says, well, I don't want my kids to get the money until they're 25 or 30 or whatever. And then they name the kids as the beneficiaries on those life insurance policies and on those IRAs. What happens then is you've got a 19-year-old kid who loses their parents. And the parents did do a will that says, I don't want the kids to get it until they're 30. But the kid is the named beneficiary on the IRA and on the life insurance. And that overrides what the will says. Meanwhile, that same young family could set up a trust and name the trust as the beneficiary, and that would let them hold all of that value going forward. Even though they don't have the money now, it plans for it in the future.
Right. So, and also I think we see a lot of young families with, a life insurance payout might be their biggest asset at this point in time if they were to pass away. but that life insurance policy might be for $1 million, and you definitely would want some structure on how that is distributed versus just an outright distribution.
Oh, absolutely. I mean, think of all of our friends coming out of law school who with a negative net worth. I mean, they're worth less because of their student debt than zero, but they put a lot into these, well, a little to get a lot from a term life policy. So just balancing those things out. Yeah. So I think when you say, is there a time for someone to do a trust? The trust is just like a will, just like a power of attorney. A trust is a solution. It's a tool that we use to make sure that what you want to have happen happens. So the first question is, what is your goal? What is it you're looking to accomplish? And from there, we figure out, does a will make the most sense? Because if you want to name guardians for minor kids, there is no trust that can do that. That's the work of a will. But if you want to hold assets for the long term, if you want to shield assets, then one type of trust or another might be a better tool for that. Because even when we say trust, all we're doing is talking about another big category of legal documents, of legal entities. By saying trust, all we're saying is, car, and not distinguishing between a Prius, a Corvette, stretch them up.
Yeah, it's a really good answer to the question, because so often people feel like there's a threshold of net worth that requires a trust. And to your point, it just really all depends on the goals, and there's different solutions and what's important to you.
Precisely. So that kind of brings us, I see a question here from Donna about losing control of assets. So what I'd like to do, Mike, is just ask real quick. I hear a lot about revocable trusts, irrevocable trusts, that kind of thing. What irrevocable means unchangeable, right? It means I can't do anything. Once the money's in there, I lose total control and it's carved in stone, right?
Sometimes.
Sometimes.
But most times not. And then that's a struggle that we deal with all the time, is just those terms that people are familiar with when it comes to trusts. I would say 90% of people out there, when you're talking about a traditional family trust, they have a revocable living trust. And irrevocable trusts, to your point earlier, are used when certain goals are trying to be accomplished. Are we trying to protect assets? Are we trying to lower the taxable amount of the estate? And I think that's where people are most familiar with the term irrevocable trust. One, from ILIT policies, which are irrevocable life insurance policies, back when estate tax was much less, when it was $100,000, $200,000. So many people were subject to estate tax, where irrevocable trusts were a great tool, because the goal was to pay less tax, to take money out of your estate so that you didn't have such a taxable estate. And that's where people get caught up, or, just when talking with families about this stuff, they start Googling irrevocable trust, and you're going to find all kinds of great information about trusts where you put assets into and you can never touch them again. You can't change who the beneficiaries are. You can't change the terms of the trust. And Pat, is there any trust out there that you don't have to just lose control of everything?
Interesting. There's a few like that. First, I think, I think it's important to define exactly what that term revocable or irrevocable means. Revocable means dissolvable. It means you can revoke the trust. You can destroy it, dissolve it. It doesn't exist anymore. What irrevocable means is that you can't dissolve it. You can't just unmake it outside of extraordinary circumstances, that sort of thing. What irrevocable doesn't mean, though, is unchangeable or unamendable. It doesn't mean that you lose all control. It means that you can't just unmake the trust. So just to understand those two categories. So to answer your question, any revocable trust is going to be amendable, because if you can just dissolve the whole thing, well, then you can dissolve parts of it and replace it with other parts. When it comes to irrevocable trusts, of which there are many different types, some of them you're very restricted on. Some of them you have no control, you do lose control, but you might do it for the tax benefit. But there are also irrevocable asset protection trusts where you remain the grantor, the person who puts the stuff into the trust, and you're also the trustee. So as long as you're alive, you can make use of the assets in the trust, you can benefit from them, you can manage them. You can ultimately change who's in control and who things are going to. And then when you pass away, those assets will go to the people you want them to go to. But during your lifetime, that allows those assets to be shielded, to be protected from things like lawsuits, the cost of long-term care, that sort of thing. And so people will set up trusts like that if they're concerned about those long-term care costs, or, you know, some of the people we work with who are physicians, people who own multiple rental properties, police officers, somebody who is at high risk for lawsuit, they might set up a trust to protect from that. Though, admittedly, a great deal of the people who we work with are more concerned about the cost of long-term care, increased nursing care costs, that kind of thing, than direct lawsuits.
That's good stuff. And I think the long-term care stuff, I mean, we could probably talk about that for another hour. That would probably
so maybe next time on that.
I think that would be a good one for our next one, because we get a lot of questions on that. And you want to make sure you're using the right kind of trust when doing those things. Mm-hmm. In my experience, at least, I get a lot of questions about people being offered more restrictive, irrevocable trusts to try to accomplish protecting assets from long-term care. And that doesn't need to be the case. There still are trusts out there that you can maintain control of the assets with, just like you were talking about.
For sure. And there's nothing that I shouldn't say nothing. For virtually any strategy that we're going to advise on, I don't like being caught in a position where there's no way out. So anything that we do, we want to have a way of undoing, a way of going back on. And because that way, if we go one direction and things change, we're able to back up and go another direction. And if we couldn't do that with the trust planning that we do, I would be a lot more uncomfortable with it. But because there are ways to manage things, there are ways to adapt going forward, it's a much more flexible way of handling things. I was just going to give one other example of a type of trust that used to be incredibly common and you don't see a lot of anymore, except we see them because people bring them in. And those are what are called AB trusts. They were really, really common back in the day. There's a ton of families out there who have these trusts where husband has one trust, wife has one trust. And the idea with those was to split up your assets so that they would be under the estate tax threshold. So for like 20 years, from the 80s until the early 2000s, late 90s, around 2000, 2001, the estate tax was at $600,000. If you had more than 600, you would pay tax on that. So what people did was they set up these two trusts where they say, we have $1 million, put 500,000 in your trust, put 500,000 in your trust. Now look, we're both under 600,000, so no estate tax, which is great. There was a reason to do that back then. As things sit today, here in 2020, the estate tax exemption is not 600,000. I'm sorry, exclusion amount is not 600,000. It's $11.4 million. Meaning, if you have less than 11.4 million, you will pay no federal estate tax. And Michigan has no state estate tax. And just to be clear, that number does double for a married couple. So if you're married, it's not 11.5, it's 22.8 million. Now, I do
have a question for you on that. With the AB trust, it sounds to me like that would be incredibly difficult to manage in the event that one person passed away, because now you have multiple trusts and you have things going on. Could someone consolidate the AB trusts as a married couple into a joint trust if that made more sense right now?
Yeah, can and should. Now it's not necessary. Well, should in most circumstances, because the estate tax is not going to stay where it is. It is going to drop in 2025 all the way to $5.5 million per person. Again, double that for a married couple. But if you've got a married couple that has an AB trust, there's a lot of kind of oddness and awkwardness that goes along with that. The first thing is you have to divide your assets. So what that means is you have a trust, husband has a trust, wife has a trust, and it's okay, the house is going in your trust, but the brokerage account is going in my trust, and the cottage is going in your trust, and the savings is going in your trust. That is a weird way to handle things, especially because when one person passes, now you have all these assets that are held in this other trust that then need to be put into a trust for the other one. Whereas if they have a joint trust where they're co-grantors, co-trustees together, there's no need for any of that administration, no need for dividing those assets. And right now, there's no benefit for most people in having the AD trust. Now, there are some states that still have estate taxes. Illinois has a $4 million. If it's more than $4 million, there's an estate tax there. And so there are still some reasons you might want to have separate trusts, but for the vast majority of people in the vast majority of situations, there's just no benefit and no need, just a lot of extra hassle.
Right. And I don't know if you experienced this, Pat, but I've had this happen a couple times where the AB trust situation was drafted by an attorney who maybe didn't practice in this area quite often, and it restricted the spousal's ability to get access to the marital or family, one of the trusts that was created out of that AB situation, where she actually, he had passed away, she was still living, and she couldn't get access to the money because of how it was written.
Things got real bright over here all of a sudden. There's a lot of language, especially the older you go back in some of these trusts, especially where there was a very strict divide between where the money was coming into the home from. And so you'll have these things set up where basically maybe it wasn't intended that way, but it winds up putting a ton of restrictions on the spouse. We've had them where it is an outside bank is basically giving an allowance, to the living spouse, or putting restrictions on that probably were not the intention of the original grantor, the person who set it up, but that's what we're stuck with at this point. And not a lot of people are thrilled with the idea of when my spouse passes, I lose control of a chunk of half of my assets. That's not great.
Sure.
Yeah.
Hey, there's a really good question over here that I want to kind of tackle as we're going through some of this stuff, because it relates to a revocable or irrevocable trust, really any kind of trust. But Angela Lynn had asked if essentially her question is can you make different provisions for each beneficiary under your trust? So let's just say you have 3 kids, and 2 of your kids have great heads on their shoulders. They're 35, 40 years old, no issue there. And maybe you want to make an outright distribution to them. But you have another child who maybe struggles with, addiction is a very real thing right now. Mm-hmm. And maybe he struggles with addiction. The question is, can you treat them all differently? And how do you do that? And the answer to your question is absolutely. In a trust, you can get as creative as you want with each distribution. You don't have to give everything equally to everyone. You could say, 10%, 80% if you want to. You can do whatever you want. And then as far as each child goes and how that distribution is, you can have it be completely different. You can get really creative with one and essentially maybe do like some type of retirement plan for them. You can do 5% annually for 20 years, where the other 2 kids, you're like, no, they can just have it outright. So that all kind of comes out during our planning process, and we give people a lot of different things to think about as we're working through those. But it's a great question, and absolutely the planning strategy can be completely different for every single beneficiary that you have.
You mean it's not like a cookie cutter, one size fits all type of planning?
It is not.
Oh, okay, interesting. Yeah. There was a question earlier up here. Will I lose control of my assets if I fund them to my living trust? Well, I guess the first question is, what is funding? Funding is just paying the lawyer to set up the trust, right? That's funding the trust.
Right.
Right?
No, absolutely
No?
not. No, that's
Go
a great
on.
question. And so, just as important as setting up an estate plan is making sure if there is a trust to put your assets or tie them in some way to the trust. Because if you don't do that, you're just creating a really expensive will that will go through probate and not accomplish any of the things that you wanted it to. Now, as far as what does funding look like and how does that work? Every account is different in how it ties to the trust, and there's going to be recommendations that we make on how to tie each asset to the trust. But this is things like if you have a life insurance policy, the beneficiary of the life insurance policy should be the trust. Not in every situation, but in a lot of them. That way, the funds pay out to the trust first, and the trust has all that great language that we built to make sure that it goes to who you want it to go to, the way that you want it to, when you want it to, and everything else that we intended. Does that make sense?
It does. There's this question here, how do homes and properties tie into the trust? That sounds like a funding question as well.
It is. Homes, properties, real estate, then we need a legal deed in order to make the change. But again, it all depends on what we're trying to accomplish and how we fund it to the trust. Sometimes we use a tool called a Ladybird deed, which essentially, in the easiest way to describe it, is like putting a beneficiary designation on your home. Or sometimes we put it in trust immediately in situations where maybe we're trying to protect the home, or there's different reasons why you would retitle it today into the trust or make it the beneficiary, like with the Ladybird deed that I was mentioning. But in any event, we have to tie the house or all real property to the trust to accomplish most people's goals.
Gotcha. So it does sound like it's all a little bit different because those are both different types of deeds, right? But they're both types of quitclaim deeds, aren't they? A Ladybird deed and an ordinary quitclaim.
That is a great question that we get so often. Is people ask, what's the difference between a quitclaim deed and a Ladybird deed? And without getting too, we're trying to condense an entire law school career into 15 minutes here. But, there's essentially warranty deeds, quitclaim deeds. They're just types of deeds and what warranties you're transferring to the next person. I'm not going to get into that, but essentially a Ladybird deed is a style of quitclaim deed. So they are one and the same, essentially, where one has a provision in it that says, I have the ability to control this asset during my lifetime, but when I pass away, it goes to this person.
Gotcha.
And so one thing I do want to point out is that if you do have an estate plan, making sure it's funded is incredibly important. The process can be complicated and there's a lot of things to think about. And so often we meet with families who have a plan that they want us to update, and we will go through all the updates they want to make, the changes. And then at the end of the conversation, we ask, well, okay, now can you tell us, what's in the trust? And we always get this kind of deer in headlights look like, what do you mean what's in the trust? I had an attorney drafted, isn't everything in the trust? And unless you take steps to tie every single asset to your trust, it doesn't get funded. So a lot of times that becomes so complicated that actually most times we handle that for most of the clients that we work with.
Gotcha. Well, and I just have to say on the is this trust funded? I will have people bring in a trust and open it up and ask me if it's funded. The thing is, a funded trust and an unfunded trust look exactly the same. It's the exact same document. You can't check if a trust is funded by looking at the trust. You have to look at the title to the home, the bank statements, all of that, not just the trust itself.
These are good questions coming in and they're hard to keep up with. But I just saw a good one that touched on something else that we were talking about. Angela Lynn also asked, essentially her question is, who can be the trustee of the trust, and what is a trustee of a trust? And with that, I think the easiest way to describe what a trustee is it's someone who's going to manage the trust that you create after you are no longer able to do so. So you guys see my kids running around in the background? Yeah. Work from home life, right? We're all doing it. They're going to come in a minute, just FYI. And then the dog's going to start barking, but we're good. You can pick, a family member to be trustee. Typically, you are the trustee originally. If you're married, you and your spouse are trustees in a joint trust. After that, we need to pick who's going to manage these trust assets and follow the rules of the trust after either death or incapacity. In any of those situations where you can no longer manage it, you have a successor trustee who's going to manage the trust. You could have a family member do this. You can have anyone else do this. You can have a fiduciary do this job, or you could have a corporate trustee. Now, what I typically tell people is with a fiduciary like our office, CPAs, financial advisors, or anyone else who can take that role, or a corporate trustee, there's going to be fees involved. So if you have people you can trust, family members, absolutely use them. They owe you, right? You raised them. But if you don't, if there's family dynamics that would just make sense to have someone else manage it, we are always more than willing to do that for families. Different bank institutions have those trust departments as well to take on that role.
Gotcha. So there are options, even if there's no one in your immediate family who you would want handling that.
Absolutely.
Yeah, and I would just to reiterate on that one, not to put kids necessarily in a hard spot. If you're disinheriting someone and they don't necessarily know that that's coming, don't make their sibling be the one to deliver that news. Things like that.
Yeah, I would agree with you there, Pat. We're going to have some conversations around those types of planning ideas, right? If we're not leaving equal distributions to kids, if we're disinheriting people, but there's some other things to be thinking about just to make sure it all goes smoothly. So really good point on that. Another question about funding property out of state. Let's say you have a house in Florida that you're not allowed to travel to right now. Should that be in your trust? And the easy answer is absolutely. I mean, everything you own should be in your trust as far as assets, property, retirement accounts, bank accounts, all of that should be tied to the trust. So good question there.
There was also a question earlier about can I leave some of all of my assets to an organization of my choice, like a nonprofit? Short answer is absolutely. Long answer, particularly if it's IRAs. Now the law changed on those quite a bit, but there are some particular issues where you can run into tax consequences by giving part of an IRA to a church or charity, and then part to kids or human beings. Just to make sure if you are going to do that, that you talk with an attorney and you talk with the CPA to make sure you don't inadvertently cause tax issues and tax issues for those folks.
Another question I'm seeing here, there's two of them that I can kind of tie together, is what if I want to make some changes to a trust? I don't know what's going on back there. What if I want to make changes to an estate plan that's already in place? Do I have to start all over? And then also, what does the process look right now with everyone kind of being quarantined to their, with social distancing and everything like that? So the short answer, let's just talk about it in normal times, because it'll apply for now also. But any attorney can change any trust. Just make sure that they know what they're doing. So we'd always be happy. Go ahead. That is a pretty generic statement there. Go ahead.
When you say any attorney can change any trust, yeah. I think I get what you're going for, but that seems quite broad.
That is quite broad. Yeah. So if we're talking about a Michigan, if we're changing a Michigan trust here in the state of Michigan, make sure it's a Michigan licensed attorney that's doing this. I would make sure that this is something that is part of someone's regular practice, because there's definitely some nuances that that you could screw up if you didn't know what you were doing.
Would you recommend getting it done by a divorce attorney?
I would not.
What about a car accident attorney?
I would not as well.
What about somebody who specializes in elder law and estate planning?
You're getting closer.
Okay, all right.
You're definitely getting closer.
Maybe the practice that's focused more on the trust planning, asset protection side of things?
Yeah, maybe. The one thing that we talk about always in our practice is you're not going to know if what you did works until most likely you're unable to know or you've passed away. So that's where it's incredibly important to because any attorney could download a form online, say, oh, here's a trust. It does everything you said you wanted it to do. But then someone passes away and it does none of the things you wanted it to do. So I think it's really important, just to circle back on that, is to use someone who you've vetted, who maybe you've talked to someone who used them before, and this is their area of practice, not the divorce attorney. Not that there's anything wrong with that. They're going to see a big uptick here in business coming soon.
I was going to say, it's very much, I know I personally and us as a firm have a strong philosophy of stay in your lane. We don't do divorce. We don't do personal injury. We don't get into the areas that aren't what we specialize in and what, candidly, I think we're pretty good at.
I would totally agree with you on that.
All right.
Hey, Pat, the second part of that, if you could touch on it, is, so what are we doing for meetings right now?
Yeah, so
what does the process look like?
Anything and everything that we can while abiding by the governor's orders. Right now, we are doing a great deal of kind of online virtual meetings through Zoom, phone calls for people who either have access to technology or who just aren't comfortable with that. Zoom, for anyone who's not familiar, is a voice chat software. And I can't tell, am I a little garbled now?
A little bit.
But so that's the idea with Zoom. And we've been meeting with families. Candidly, this week has been slammed on our side with just all of these phone calls, all of these Zoom meetings, that kind of thing. And then we can follow up through email. We can draft everything and then either send documents. I've got a whole stack of FedEx boxes over here for sending plans out, reviewing things online, just doing whatever we can to make things work in this environment. I mean, we've been planning and working on the virtual side, the online side of our office for well over a year now. It's just up until last week, no one was really that interested in it, and all of a sudden, people are doing it.
I think everyone that we're working with is finding it to be incredibly easy. I know, like, for instance, all age demographics my kids are meeting with their teachers on Zoom. My wife's parents are Zoom. We're having Zoom meetings to have dinner with them because they can't see their grandkids. So I think everyone is being forced into this virtual environment, and it's becoming just easier and easier. I mean, you can be on your smartphone and click a button that we send you that automatically gets you in. Between FaceTime, which is incredibly easy if you're on the Apple platform. This is way easier than I ever thought it could be. And just, document trading through FedEx and doing it that way and going over things with families still being able to see them. And at the same time, kind of delivering, able to answer their questions and do everything that we were doing before.
For sure. Plus, people are a lot more, it's been a lot easier to schedule things since there's no longer, or at least much reduced, the question of, well, I'm busy now, but my spouse is doing this and this and that. It's like, no, we're sitting at home. We've been talking about this. We've been meaning to do it. And we're just sitting here for 12 hours. I think we can find time to do that together in front of our computer and get some questions.
Yeah, estate planning for sure is kind of one of those like maybe bucket list items or things that everyone tries to check off, and just life gets busy. And right now life is not busy, and because we can utilize this technology, it's been great to be able to still serve families.
For sure. There's kind of a string here from Angela that I think goes together well. Where it's, what if I wanted to make changes? Do I have to start all over? What does it cost? How long does it take? Kind of those big structural questions. So would you like to take the what if I want to make changes, or what does that process kind of timeline cost us?
Well, easy enough. I already did the what if I want to make changes.
Okay, all right.
So right back at you.
I see how it is. So I do just want to say, if you want to make some changes, it really does depend. In some cases, it does make sense to start over. In some cases, it makes sense to amend things. One of the things that we do come across here are like what you might call like a Franken trust that started out back in the 70s and has been amended and changed and tweaked over the last 30, 40 years, where you've got all these parts kind of cobbled together onto it. Often it makes sense to either fully restate or fully redo a plan like that so that it works together coherently and cohesively. So sometimes it makes sense to just make a little tweak, and sometimes it does make sense to tear down and redo. It's like a home remodeling project, Are we going to patch the drywall, or are we going to replace the whole thing? And you got to look at each situation and figure it out from there, which takes us to what does it cost and how long does the process take?
Pat, I know you touched on it last time, but are you guys offering any incentives to work through this virtual process?
Look at you cutting me to the quick. So yes, we absolutely are. As all of us are on lockdown, working from home, and trying to avoid looking at our IRAs and 401ks. We know that things are a little intense out there financially, because out there is in here too. We're going through the same thing that everyone is. So trying to meet folks in the middle. People want to get this planning done. They understand how important it is, but also things are tight. So we reduced the investment for working with us by 50% on our estate planning. Meaning, if you choose to work with us during this time, you take the jump to meet with us on Zoom or whatever it may be. The cost for getting the work done here, that investment is reduced by half. So hopefully that makes it easier for you to make that decision, and that helps us keep people on, keep the lights on, keep things going. When it comes to cost, half of what it would have a month ago, and half of what it would by the time we're on the back end of this. So as long as we're in this, we're working it out that way.
Angela talks also about process, which is usually the two things that we always go over. But the process is all dependent on availability. And in a normal environment, we usually have about a week between meetings. I'm finding that people and really what our process looks like right now is scheduling that initial Zoom meeting, FaceTime, whatever, to just kind of go over and let's talk about goals. It's very informational, get your questions answered. We work all on flat fee pricing. So at the end of that conversation, we can let you know exactly what it's going to cost. We give you some information during that meeting, which then it gives you the ability to make decisions on, how am I going to distribute my assets? Who are going to be the trustees, the financial, the medical powers of attorney? Who are going to be my agents, in what order? We give you some really good things to think about. There's usually about a week between every meeting. Right now I'm finding, because people don't have a lot to do because they're stuck in their homes, we're scheduling, a couple days just to think about a couple things and then get back on Zoom and answer some questions and make some decisions. So, our typical process was always about 4 to 6 weeks, start to finish, funded estate plans. Now you're more, we just kind of roll with whatever is best for you. And that could be as a couple weeks. It just really depends. I don't know if I think that covers it though.
Yeah, I think that was a very lawyerly way of saying, yeah, it depends.
It all depends. It always
It
depends.
but it definitely has become a little bit more condensed since people aren't doing as many other things as they would. You know, they take the little bit of time that they need to sort it out. Um, can I pay for this in a couple installments? Yeah, you know, we're pretty flexible when it comes to working with people, understanding that a lot of the folks who we work with are on a fixed income. Additionally, you know, right now, even if somebody says, "Hey, that's something that I really want to do," you know, how do we make sure that it works within the means of all the different types of families that we serve? Because there are folks who we work with who are paycheck to paycheck. And we have people who are very much on the other end of the spectrum, and we're planning for property across the country. So it just depends where people are at. We want to meet you kind of where you are.
Right. I think we're getting on to, we've almost been on here for an hour.
Yeah,
Crazy.
I think that is way more than anybody wanted to listen to us, and I can't say that I blame them.
Thanks for being here.
Yeah.
All right. So let's talk about what we're going to talk about next time. So we should dive a little farther into asset protection trusts. Let's talk about long-term care, what that means to protect your assets from long-term care. What else?
And maybe we haven't touched on separate share trusts, supplemental needs, or underage. I mean, there's a whole bunch there that can protect your kids. So maybe next time we talk about protecting you, protecting your kids.
Yeah, for sure.
All right.
Love it. All right, Pat. Thanks for being here.
Absolutely. And Mike, when is that next informative Facebook Live?
It's a really good question. I'm pretty sure it's Monday at noon. Monday, let's look at a date here.
Yeah.
Monday the 6th at noon.
Same bad time, same bad channel.
Exactly.
Right. I have MetLife through my job. Do you guys work with that insurance? We certainly do.
We certainly do. Yeah, if you great question. If you have legal insurance through work, there's a bunch of different providers for that. We typically take them all. So we'd be happy to look into what's covered for you, because it's usually different for each individual. But yeah, we absolutely do that.
All right.
Time to sign off?
I think so.
All right.
Until next time.
Yeah, be safe and well.
Cheers.